Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. Another big case today at the Supreme Court. This is Garland v. Cargill, and it involves whether the ATF, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, is allowed on its own to clarify that bump stocks qualify as machine guns and are therefore banned under federal law. Let's listen to a clip of Justice Neil Gorsuch taking up this question at oral argument.
I can certainly understand why these items should be made illegal. But we're dealing with a statute that was enacted in the 1930s. And through many administrations, the government took the position that these bump stocks are not machine guns. And then you adopted an interpretive rule, not even a legislative rule, saying otherwise, that would render between 250,000 and 500,000 people federal felons. And not even through an APA process they could challenge, subject to 10 years in federal prison. And the only way they can challenge it is if they're prosecuted. And they may well wind up dispossessed of guns, all guns in the future, as well as a lot of other civil rights, including the right to vote. There are a number of members of Congress, including Senator Feinstein, who said that this administrative action forestalled legislation that would have dealt with this topic directly.
Kim, maybe the best place to start here is, can you give us a sense of what a bump stock is? And how do we get to this point that we're having this argument about whether the ATF has the power to ban them on its own?
Sure. To understand this, you have to understand that guns are specifically crafted in different ways with different actions, okay? And the definition of a semi-automatic weapon is one in which it fires when you pull the trigger, each time you pull the trigger. The definition of an automatic gun is one that fires multiple rounds with a single function of the trigger. And that is written into law. It's very clear, black letter in the law. That was the definition that was put forward, as Justice Gorsuch says, back in the 1930s. It has been abided by the ATF and others and manufacturers for years since then. And we regulate in this country quite aggressively the ownership of automatic weapons. For the most part, they are only allowed use in the military. There are some grandfathering things for some older ones, but you cannot, as an individual, go out and buy an automatic firearm. A bump stock is essentially a device that fits along the bottom of the gun, and it works in such a way that the recoil of the gun, your finger is essentially sitting there with the recoil of the gun, bumps your finger on the trigger faster than in theory that you could do if you were just pulling the trigger on your own. The ATF argument is therefore that this essentially makes them machine guns. Now, we can go into why that's not really the case. Real machine guns actually fire a lot faster than even things with a bump stock on them. But the big point here is the legislative question, which is whether or not you think bump stocks should be made illegal. I don't necessarily think they have great purpose in terms of firearm ownership and Second Amendment rights. But whether or not you think they should go or should stay, that is a question for Congress to deal with by changing this. And as noted, the ATF in the past, all the way up until 2018, in the wake of this Las Vegas mass murder we saw in which someone used a bump stock, always took the view that a bump stock did not make a weapon into an automatic gun, that it changed on a dime in 2018. And I think the issues here are both the legislative question, but also, as Neil Gorsuch noted, the extraordinary penalties that ATF has just come up with very little to no authority to change anything out there without Congress's approval.
That's part of what makes this a fascinating case is it's about guns, but it's not exactly a Second Amendment case. It's more of a separation of powers case. And I spoke to a Second Amendment advocate this week who said that in his view, bump stocks were kind of a novelty. They're kind of fun to use at the firing range, but they degrade accuracy because the gun is bouncing back and forth against your trigger finger. And so they're not the way that you would want to go hunting. They're not quite that useful in self-defense. And so personally, maybe there's an argument for treating them with similar kinds of regulations as are faced by automatic weapons. But Monet, I think there's not really an argument that that's the job of Congress, not the job of the ATF. You can look at the definition in federal law of what a machine gun is. And it seems clear to me, and it seemed clear to the appeals court below, that it did not include bump stocks. And as Justice Neil Gorsuch described there in that clip, after that 2017 Las Vegas shooting, there was a push to have Congress pass a law specifically banning gun stocks. And you had people like Dianne Feinstein saying the ATF does not have the power to do this. And yet, as we often see, the ATF tried to do it anyway. And so here we are at the Supreme Court.
Exactly. I think that the bump stock question, like a lot of questions of how the government treats how certain devices can be used, is a question of nested authority. It obviously begins with the Second Amendment of the Constitution, which basically provides protection for all modern, regular, common use weapons. And nested within that is the authority of Congress to create more specific guidelines around which types of weapons the public is able to purchase and use without violating the basic outline laid down by the Constitution. And then only finally does the ability of the executive branch to come in and pass specific regulations come, but they have to do that within the authority that's been explicitly provided to them by congressional statutes. As Neil Gorsuch was suggesting, the relevant statute on machine guns clearly doesn't fit the exact definition of bump stock. It doesn't regard a single trigger action, even though it's modifying it to make it easier to pull the trigger. It is individual trigger actions, which means that if Washington wants to make it harder for the public to access these weapons, they have to make an addition to that statutory power, which only Congress can do. And so the Fifth Circuit seems to have got it right. It seems as if the Supreme Court is leaning towards that interpretation and suggesting that just because there might be broad will to regulate bump stocks, and there might be even some practical reasons to do that, doesn't mean the ATF can go out and do it on a whim without getting specific congressional authority to do so.
Thank you, Monet and Kim. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.